J'ai donc le plaisir d'introduire cette première table ronde pour présenter les aspects de droit comparé. Je crois qu'il n'est pas utile d'insister sur l'importance du droit comparé, surtout depuis le règlement 1 2003 et le fonctionnement en réseau. Cela a multiplié les intérêts. Donc, l'introduction ayant déjà été faite, je vais me contenter de présenter rapidement les membres du panel, en commençant par ma droite, donc Corinne Dussart-Lefray, qui est chef d'unité à la DG Concurrence, Catherine Rosel, qui est chef d'unité également au Bundeskartellamt, Stephen Black pour le Competition Market Authority, et puis nous aurons également le regard d'un praticien, Laurent Guéland, avocat, mais qui, dans une vie antérieure, a été longtemps juriste d'une grande entreprise multinationale. So I will switch now to English. We have decided to organize our panels in three parts. We will try to have these three parts. The first one on the general context, the second one on the procedure itself, and the third one on the consequences of a settlement decision. So for the first two, my questions are mainly the same for the representatives of the competition authorities. First, why and when have you adopted a settlement procedure? Was it through a text of hard law or only through text of soft law, or maybe it's only informal procedure? Second question, very important in the French context. What is the field of your settlement procedure? Only cartels, only horizontal agreements, or all anti-competitive practices? And third sub-questions, in practice, what is the use of the settlement procedure in your legal system? First, I turn to Corinne. I will give you the floor. Of course, you may skip the first questions in the European context and maybe focused on the practical use.
Okay. Okay, thank you. So you know that the settlement procedure is only for cartels. So a settlement is different from a commitment decision or Article 9 decision, and also is different from a decision under the cooperation procedure, which is a new procedure I will explain a little bit more in detail. So a settlement decision establishes an infringement and requires an admission of guilt from the party, whereas a commitment decision, for instance, does not establish an infringement and does not require any admission by the parties. A settlement decision requires a cease and desist of past behavior, whereas, of course, commitment decision requires only commitment to future behavior. A settlement is not a US plea bargain either. So we have to show the parties that we have sufficient evidence to bring final decision, and we must send a statement of objection in a second stage. In 5 recent antitrust non-cartel cases where commitment procedure was not possible because those cases should normally lead to a prohibition decision, we have decided to reward the company's cooperation. So the same rationale was applied, so allowing for simpler procedures and a reduction in fines. And the level of the fine reduction depended on the extent and timing of the cooperation and resulting benefits in terms of efficient procedure and effective enforcement. Because for us, the main objective of the settlement or the cooperation procedure is to have a faster decision, and the main gain is at the level of the access to file and the litigation stage. Maybe I can continue on that. So now we have the settlement for 10 years. More or less 54% of our decisions were adopted under the settlement procedure, and also 54% of the fines. since 2014, so there is a clear reversal in the trend, and then we have almost all our decisions are settlement decisions. I speak about cartels now. And the settlement procedure is, in average, 2 years shorter than a normal procedure. We think it's a clear success, and it should be in the toolkit of any cartel enforcer. In the course of these 10 years, companies and officials have become familiar with settlements. This has been tested by the judicial review of our court. And during those 10 years, we have adjusted and improved our practice accordingly.
Thank you very much. What is very interesting for me is the fact that as true, within brackets, settlement procedure was limited to cartel, you had the need to introduce this new informal cooperation procedure, but maybe it's not so new. Laurent will come back on this point later on. I now I will give the floor to Catherine to present the German experience.
Thank you very much. In Germany, we also have a consistent practice of settlement negotiations in administrative fine proceedings for the past 10 years. So this is for almost 10 years. And around 80% of the undertakings that are in focus of our investigations and proceedings do settle in the end. That does not mean that 80% of our cases are settled as a whole. We have very often hybrid settlements. Most of the cases go to court, but not all of the undertakings. We see advantages or many advantages for all sides involved. So settlements can shorten complex and resource-intensive cartel fine proceedings. For us, it's a very important procedural instrument, and one reason is that we have in German 2 different proceedings. So we have the normal administrative proceedings, which are very similar to the commission proceedings in merger cases, and we have administrative fine proceedings, and there we face a very high standard of proof in court proceedings. So these proceedings are based on criminal procedural law, and the court, if it goes to court and our decision is not reviewed, the court takes a new decision and has to hear all the witnesses again. So just to give you an example, so one case can take about 40 to 100 days of court proceedings until the end of the decision. So there you can see the lengthy proceedings might be one reason why, or is one reason why these instruments is valuable for all sides. We have no specific legal basis or no specific rules and no formal requirements under ordinary law. However, we have constitutional requirements defined by our German Federal Constitutional Court for settlements which we regard. So there was no legal act, but it's part of our discretion in administrative fine proceedings to grant a settlement reduction if there is a confession or a settlement declaration. Settlements can take place in any administrative fine proceedings. So it applies to horizontal and vertical agreements, but in practice, our fine proceedings have a clear focus on horizontal cartel prosecution. So, but they could also be applied in any other fine proceedings. Yes, so maybe to the procedure we come in the second round.
Okay. Just a question.
Yes.
Does it mean that you don't have criminal fine proceedings for abuse of dominant?
Yes, we do have the possibility of criminal proceedings or sanctions for abuse of dominance. But as with regard to our high standards, many proceedings are taken in form of administrative proceedings and not in fine proceedings. So in practice, the main part is cartel prosecution.
Okay, that's an interesting point to understand the German legal system.
Mm-hmm.
So I turn now to Stefan to have a look at the other side of the channel.
Okay, well, not surprisingly, I think many of the themes that have been aired already are common to the system in the UK. In terms of the purposes of the settlement procedure, we've had a formal settlement procedure since 2014, so since the creation of the Competition and Markets Authority, and the reason for that is to achieve procedural efficiencies for the CMA and to resolve cases more quickly. When we're talking about settlement, as in the case of the European Commission, we distinguish that from commitments. The outcome of a settlement case will be a formal infringement decision on the basis of an admission by the parties, and the admission will be to the facts and the legal case that has been presented to them by the CMA. And when we talk about the procedure, I can say a little bit more about the form that takes, and then that will be accompanied by the imposition of a fine which the parties agree to pay, and that fine will incorporate a reduction to take account of the fact that the parties have agreed to settle. The current procedure has been in place, as I said, since 2014. It has its basis in the Enterprise and Regulatory Reform Act, which is the Act of Parliament which created the Competition and Market Authority, and which allows for the provision of a settlement procedure or the inclusion of a settlement procedure within the CMA's rules. And the CMA's rules are a form of secondary legislation which are approved by the Secretary of State. That sets out in a little bit more detail the provisions for settlement, but the real detail is contained in soft law, as it were, and that's in the guidance that the CMA publishes, our guidance for the application of the Competition Act 1998. There's a longer history, however, to settlements in the UK, which is that the Office of Fair Trading, which is one of the Competition and Markets Authority's predecessors, had in fact settled cases prior to 2014, and the first settlement case goes back to 2006, which was in the independent schools case. But that was done on the basis of, as it were, an informal procedure, and there was no published procedure and no sort of formal legal basis for that. It was based on the sort of inherent jurisdiction, if you like, of the Office of Fair Trading to conclude cases. So when the current policy was developed and was published, it was on the basis of a number of years of practical experience of settlement, and it reflected many of the lessons that had been learned. In terms of the types of cases that may be settled, unlike in the case of the European Commission, as in the case here in France, any case can be the subject of a settlement decision in the UK. So anti-competitive agreement cases, Article 101 or the UK equivalent, but equally abuse of dominance cases, Article 102 or the UK equivalent. In practice, however, very few, in fact, there is only one abuse of dominance case in the UK that has been settled to date, and that was by the Office of Fair Trading, not by the Competition and Markets Authority. I think if you look across that period, particularly if you go back to 2006 and include that informal period of settlements, you can see an increase in the use that has been made of settlement cases. in the period from 2006 to 2014, so prior to the creation of the Competition and Markets Authority, approximately 29% of infringement decisions were as a result of settlement. Now, that's already quite a significant percentage. But if you look now at the period from 2014 to 2018, that figure increases to 63%. So the majority of cases, of infringement decision cases by the CMA have been on the basis of a settlement.
Thank you very much for these precisions. Now, Laurent, do you want to make...
Oh, it's always difficult to speak after three regulators. So I have two hats. I have the hat of a former head of legal of Michelin for Europe, having been involved in many antitrust investigations. And then I have the hat of a plaintiff's lawyer representing victims of cartels. Let's first use my Michelin in-house lawyer hat. I would say first, I think before speaking about legal issues, about law, I think you need to speak about the way companies operate. Any investigation, may turn into a nightmare. It may start as something very, basic, very simple. You don't expect any issue, and it may become something huge, with potential huge damage in terms of reputation, I would say fine, etc. And obviously, as a company, you want to focus on your business. And so you are in a damage control mode. First thing you try to do is to make sure that there are no charges against you. I would say that's the first step. And then if things move into the wrong direction, what do you try to do? You try to find a solution with authorities, possibly through a commitment decision. And then if this does not work, you move to the next phase, which is obviously a settlement decision. Then maybe I can move to what I call with Laurence, we call soft law. You all know, or most of you know Michelin 2, 2001. We were the first repeated offender in the history of the European Commission for abusing a dominant position. Well before 2001, in 1998, we had, I would say, intense discussions with the Commission. And we tried, I wouldn't say to settle, but we try to find a solution, and we negotiate commitments with the European Commission. So we stopped several behaviors, and we committed not to, let's say, pursue, repeat those behaviors. And we really thought that the case would be closed. We were discussing with the Maurice Guérin, who was, I think, a director general of the DG4 at that time. And then he retired. A new team, came into the game. And we start again with a full, investigation, statement of objections, etc. I must say, I think that's something we have not mentioned yet. In abuse of dominant positions, the role of plaintiffs is absolutely key. In cartels, you hardly see any plaintiff. We were plaintiff in one case, in the synthetic rubber case before the European Commission. I think this is the first time, and maybe the only time, I may be wrong, there was a plaintiff in a cartel case. And I remember the Commission officials were telling us, okay, go away, you are polluting the case. We don't want to see you in our case. And maybe they were right. In abuse of dominant position, plaintiffs play a key role. And of course, we'll want to be heard by the authorities. We want the authorities to listen to them, and then you have a completely different dynamics. We had another case, this time in front of the French authority. And again, it was not about settling, but again, there was a dynamic. We discussed with the rapporteur, we went in front of the college, and we took some commitments. So we changed some of our practices, and this ended up in the case being closed. So we were very pleased about that. Why I'm saying that is to say that clearly this is a trend. I think companies don't want to spend too many resources in fighting with authorities. If I remember Michelin 2, we had the head of our truck business unit, who was our largest business unit, spending 25% of his time on the case during 2 years. And as a company, you cannot afford that, except if you are Google or Amazon. But I would say as a French industrial company, that's not possible. But we are speaking about plaintiffs. Maybe we'll come back to that. I think it's a very important dynamic. I think we'll speak later about motivations. I think there was an interesting case in Brussels with the European Commission, the envelope cartel, where a company challenged a settlement decision and actually won in court. We'll speak about that later. The trend I also see in many other countries like the Netherlands, Greece, very recent, I would say, practice, starting last year, the first settlement decisions. Not yet in Spain, but I understand it's on the agenda of the government.
Okay, thank you. Do you want to add any remarks on this general context? No, it's okay for you? So we will see later on in the general discussions. So now we have to go in the details and to have a look at the procedure itself. I have mainly 3 series of questions, but of course, feel free to add any other point. First series of questions on the conditions to settle and sometimes the link with leniency. Second series of questions on the settlement process. And we already mentioned an important point before or after the statement of objections. And maybe a third point on the settlement discount and the link with the general rules on fines. So once again, I turn to the Commission because the Commission is, of course, the leading partner in the ECN.
Okay. So who takes the initiative to launch this procedure of settlement? So in Europe, so settlement is neither a right nor an obligation for the companies. So the Commission has a clear discretion to select cases that we consider suitable for settlement. So we will carefully screen the cases and choose the cases. The criteria are, for instance, the number of companies. Of course, the lower the number, the easier to settle. The number of companies cooperating under the leniency program. So the higher the number, the easier to settle. Also, if there is a plaintiff or not. The absence of novel issues. The impact of aggravating circumstances. So, because those circumstances are likely to trigger disagreement, etc. So we will start the settlement procedure only if all parties have signaled their interest in settlement. So the requirements for settlement, so the party must acknowledge their involvement in the cartel and their liability for it. They have to confirm the fact and the legal assessment that we described in the case overview. The case overview is a core document of the procedure which serves later as the basis of the statement of objection and the decision. And all parties have to agree on this case overview. And the party also have to confirm in their settlement submission that they exercise their full right to be heard. So, before or after the statement of objections. So for us, the normal way for settlement is to have it from the start of the process, so at a pre-SO stage. Because it's really in that scenario that we benefit for more efficiency. Because the logic of this procedure is that it's an efficiency instrument, and the fact that we don't have to issue a full and detailed decision, and this SO and decision. So the parties should, in principle, be ready to settle before the Commission issue this statement of objection in the ordinary procedure, because after there is no guarantee at all that the Commission will even contemplate entering its settlement at such a late stage. Each time it's a case-by-case decision, and as you know, we only apply settlement after SO in one case, which is the truck cases, which was exceptional, and because we thought that even in that case there were still some efficiency after the SO. On the discount, so just to remind, we use the notice on fines, and then we grant a discount of 10%, irrespective of
maybe I have a remark and a question. The remark, of course, for the settlement procedure before the Commission, it's easier to organize because it's a fully integrated competition authority. So you don't have the same issues as in the French system, and we will come back and make the comparison with other competitions. My question is the following. Forget the settlement procedure, and we come back to the new informal cooperation procedure. Do you begin this informal procedure before the statement of objections, so very early in the case, or after the statement of objections?
We copied the procedure of for settlement for the cooperation cases. So for us, the main efficiency gain is the limited access to file, because for us it's very cumbersome. And then in settlement or in cooperation procedure, we give access to a limited number of documents which are key for the case.
Okay, that's a very important point, the access to file, of course. I turn now to Stephen. I have understood that the British system is more complicated than we think, because you have a kind of separation within the Competition Markets Authority. Can you explain?
Yep. Okay, well, let me try and make it simple. So that's absolutely right. We have essentially two phases, the phase up to the statement of objection, and then the phase from the statement of objection through to the final decision. During the first stage, the case will be overseen by what we refer to as a senior responsible officer, and that will be a senior director typically within the CMA, and that is the person who is accountable to the CMA board for the oversight of the case, and the person who will be responsible for making certain key decisions. That will include the decision to open the case. It'll be the senior responsible officer who will authorize the carrying out of inspections, for example, and who will oversee the whole process right up to SO, and it will be the decision of the senior responsible officer whether or not to issue a statement of objections. In the contested procedure, once a statement of objections has been issued, then responsibility for the key decisions is passed to a case decision group, and this typically comprises three individuals, senior individuals within the authority, who will be independent of the case team and people who have not been involved in the case up to that point. They will hear the representations, both the written and the oral representations from the parties, and they will make the final decision whether or not to make an infringement decision, whether or not to impose a fine, and if so, what the level of the fine should be. They will continue to be supported by the case team, but the final decisions will be made by them. Where a case is settled, however, the final decision is made not by a case decision group, but by the senior responsible officer. So the senior responsible officer who was responsible for the issue of the statement of objections will also oversee the settlement discussions and will be the final decision maker. And one of the things that the settling parties agree to as part of the settlement, and one of the procedural savings for the CMA, is that a case decision group will not be appointed. Going back to some of the points that Isabel de Silva was making when she was talking about the general principles that should apply in the case of a settlement. One of the general principles, she said, was that any settlement must be approved by a judge. Well, of course, here in this regime, we have an administrative regime, and unless there's an appeal, there is no role for a judge. But that degree of independence comes into play here in that before a senior responsible officer can enter into settlement discussions, he or she must go to the CMA's case and policy committee, which is chaired by the CMA's chief executive, and get approval to enter into settlement discussions. And any settlement that is arrived at with the parties must also be approved by the CPC. So that introduces, albeit within the CMA, a degree of oversight to the process. Going back, perhaps more generally, to the procedure, at what stage can a settlement be entered into in the CMA? In the UK regime, a settlement can be entered into either pre or post statement of objections. And where settlement is entered into pre-statement of objections, the maximum discount that will be available to the parties will be higher than where the settlement is arrived at post-statement of objections. The maximum discount post-statement of objections is 10%. The maximum discount pre-statement of objections is 20%. And the main reason for that is because the savings for the CMA are considerably greater if the case is settled before the statement of objections is issued. We don't need to appoint a case decision group, but more importantly, we don't have to give full access to the file. So one of the things that the settling parties must agree to if they agree to settle the case pre-SO is that they will not be provided with all the documents on the file. What they will be provided with is the documents that are referred to in the statement of objections. They will be provided with a schedule with all the other documents that are on the file, and they will have the opportunity to ask for further documents from that schedule. Obviously, if they ask for all of the documents on the schedule, then the procedural savings will quickly evaporate, and at that point, it's unlikely that the CMA would continue with the settlement process. And that links into one of the points that's just been made about the European Commission process, is that settlement is not an obligation, but equally it's not a right. And from the point of view of the CMA, the purpose of settlement is in order to make procedural savings. If those savings are not present, then the CMA will not exercise its discretion in favour of settlement. And there are a number of factors that will come into play. That includes the number of parties. It is more likely, it's not impossible, that the CMA will settle in circumstances where only a subset of the parties are willing to settle, but it's less likely that we will do so. So hybrid settlement is a possibility in the CMA regime, and we have had one such case so far, but that is the exception. In terms of the main terms, I think these are common to most settlement procedures. There must be an admission of liability. The parties, if the behaviour is ongoing, must cease it immediately. They must agree to pay a maximum penalty. They must accept a streamlined administrative process, and that includes streamlined access to file, as I've described it. They must accept that the senior responsible officer will be the decision maker, and also they accept that they will make limited representations on the case that is put before them, that they will limit those representations to manifest factual inaccuracies. They must accept that there will be a published infringement decision. They must agree to provide ongoing assistance with the investigation and or any appeal. Generally, of course, there won't be appeals, but in a hybrid settlement scenario, there may well be, and in that case, the settling party is expected to provide assistance there. And of course, it's always possible for a party that has settled to decide still to exercise its right to appeal, and I'll come back later to what the consequences of that would be. The settling party must also accept that where another party appeals, but it itself does not appeal the decision, then the decision will nevertheless be binding against the settling party, irrespective of the outcome of the appeal involving the other party. And finally, if the party itself, having settled the case, nevertheless decides to appeal, it will no longer benefit from the settlement discount, and the CMA will use the admission against it, but will also ask the Competition Appeal Tribunal to increase the fine in order to remove the discount. The basis for the settlement discussions will depend on the stage at which the settlement discussions are entered into. If it's post-statement of objections, then that's clear. The basis for the discussion is the statement of objections, and the expectation is that the parties will admit to the facts and the legal characterization of the infringement as set out in the statement of objection, subject to identifying any manifest factual inaccuracies. If the case is settled prior to the issue of a statement of objections, then it will be on the basis either of a draft statement of objections, which will be provided to the settling parties by the CMA, or on the basis of what we refer to as a summary statement of facts, which is a slightly more skeletal, I guess, version of statement of objections. The cases that I have been involved in settling most recently have all been on the basis of a draft statement of objections, and that's partly because of the stage that the cases, those particular cases, were at, but also that it enables the CMA to move much more quickly from the issue of the draft statement of objections to the issue of the formal statement of objections, and finally to the infringement decision. And it also reduces the likelihood of there being any disagreement between the settling parties from the point of settlement to the conclusion of the decision. And I guess a key factor, and this comes back to one of the general principles, is that the CMA will only entertain settlement really at the conclusion of its investigation. So at the point at which it is ready to issue a statement of objections, or has concluded that a statement of objections is appropriate, that there's sufficient evidence to support a statement of objections. And I think that comes back to the general point about the need for settlement to be freely entered into, and to be entered into on the basis of a clear understanding of the case against the party. And the way that that is guaranteed within the CMA system is that settlement is on the basis of, as I say, either a summary statement of facts or a draft statement of objections. Parties can approach the CMA at any stage and express an interest in exploring settlement. They can do that right at the outset. But we wouldn't engage in settlement discussions until we'd concluded our investigation and were satisfied that there was a case for the parties to answer.
Okay, thank you very much. Do you want to add something? Because
Yeah, I think it's very important. Also, in our procedure, first we start with the investigation, and there is no efficiency gain. It's a real investigation, and it's only at that stage that we decide if it's a case suitable or not for settlement. But there is no gain on the investigation phase. It's very important.
Thank you. Now I will give the floor to Catherine.
Thank you. So in Germany, we also don't have a specific time frame for settlement proceedings. So the settlement procedure can be initiated by both sides at any time. But as you already have pointed out, settlement discussions can only start when the Bundeskartellamt has a clear concept of the case and is convinced that there is sufficient evidence. But usually we don't have a formal statement of objections at this state when it comes to settlement discussions. Usually we have a written summary or a case overview in which we inform the parties about the facts of the case and the calculation or the facts that are relevant for the calculation of fines based on the latest state of investigations. And maybe let me just point out our system, how our decisions are made within the Bundeskartellamt, because Stephen, you told about the separation within your authority. So we have a case decision group at the beginning, and this case decision group consists of 3 persons. It's the head of the decision division and 2 case managers, and they take the decisions, all the important decisions, to open a case, to launch investigations, to start settlement negotiations, and they also carry out the decision at the end. So we don't have a separation within our authority, but we always have this check and balances within this group that makes the decision. But this is one reason why we don't have 2 phases, or why a settlement discussion can take place at any time as long as we have sufficient evidence, in our view. So if one party or if one settlement discussion is initiated with one party, it is open to all parties involved, but it's not necessary that all parties have an interest in a settlement. So we also usually don't grant full access to the whole file, but we grant at least partial access to the files, to all the main evidence or the key evidence. We also have a condition of a settlement declaration in which the company declares that it acknowledges the facts of the infringement of which it is charged and accepts the fine that we or the up to the amount that is announced within the settlement discussions. So and a settlement reduction can be achieved irrespective of whether a leniency application has been filed or not. So if a leniency application has been filed, the settlement can up to 10% be deducted at a later stage. But that's an important point for us. Our leniency notice applies to horizontal cartels, and in order not to jeopardize the 2 systems, settlement procedure on the one hand and leniency applications on the other hand, in horizontal cases, the maximum amount of deduction or reduction can only be 10%, so not to a higher amount. And that's the reason not to jeopardize our system when it comes to leniency. And after a settlement has been reached, the proceedings is concluded by the way of a so-called short decision, which contains the basic information and which is also published, but it's not a long decision. So when it comes to a contested case.
Okay, thank you very much. I have seen several common points among these very different procedures. One point is the fact that if it's before the statement of objections, there is always a draft or something to begin the discussion. And the other important point is limited access to file. I imagine that for a firm, these points are very important. What remarks do you want to make on all what we have?
No, I would rather say, if we look at the French system, we didn't speak a lot about the French system. I mean, you have the rapporteur, the investigation phase, and then you enter into a new game with the college. And that's something very different from the system in Brussels. And you have to be prepared for that because the college is very independent and may go against what the rapporteur says, to some extent, I would think. I think that's the first comment. So the French system is very specific, and you have to take that into account. I think the way the French system works today, and again, I'm not a French lawyer. I'm a Belgian lawyer. But I think it works very well for cartels because you don't have any plaintiff. I'm really curious to see what will happen the day you will have a very aggressive plaintiff, in a 1 or 2 case. And I don't have the clues, I don't have the response, but I'm really curious to see, the day you have very aggressive plaintiff, what will happen, what incidents, or what consequence you could have. And that's a real question. And then my third comment is motivation. We didn't speak much about motivation. I admire the motivation of the decision of the French authority. This is really very well done. Brussels, European Commission, we can debate about that. I have some reservations. I'm not criticizing, but I have some reservations, especially, and now it's my second hat, as I would say, as a lawyer of the victims of a cartel. I would say we can do a lot with French decisions. European Commission decisions are sometimes very frustrating, but that's for the third part.
Yes, but you make the transition. So we can have now the discussion on the third point after the settlement process and the decisions, the motivation of the decisions. Is there room for the infringers to contest the decision before a court? What happens to the other firms, the other companies which refuse to settle or withdraw from the settlement process? And of course, what impact for the third parties? So maybe you can begin again, okay. Cohen, because you have been attacked.
No. So normally our settlement decisions are not appealed because the party already acknowledged their liability, but there is nevertheless a room for judicial review as the fine is concerned. So far, there was only one appeal by settling parties, and it was in the envelope case by the firm Prenantes. And Prenantes won the appeal because lack of sufficient motivation. So we took that into account, and we will give more motivation on the calculation of the fine. The decision was readopted since, and there is a new appeal. We'll see. So what place for the companies which refuse to settle or withdraw from the procedure? So we have 2 ways of dealing with hybrid cases. So in parallel, so that means 2 decisions adopted at the same day. This procedure was validated by the EU courts. It was in the TMAB case concerning the animal feed phosphate cartel, or in a staggered way. So there was recently the judgment in the ICAP case. So the court asked us to take the necessary measures to safeguard the presumption of innocence of the non-settling party. So we will choose on a case-by-case basis which is the preferred option. So what place for the victim of anti-competitive agreements? So the settlement procedures lead to an infringement decision for which victims can claim compensation. So a public version of the decision is normally published in a very short period of time after the adoption of the decision. So the victims in action for damages can benefit from the infringement decision to prove their case quicker than in a normal procedure. The Commission cannot substitute to the national courts, which should assess the claims and quantify the damages. So disclosure of evidence is possible upon decision of the court and under its strict control, when the victim can show a plausible way they had suffered harm by the infringing party. So it's true that the settlement decisions are shorter, but we think that we explain the facts. We explain it's a shorter decision, but with all the provision that this decision should entail.
I'm sure that Laurent will make some comments, but that's true that the decisions make the proofs of the fault, but the main issue for many lawyers is not the faults, it's the evaluation of damages. And many plaintiffs hope to find some elements to help them to quantify the damages.
Well, I'll comment later on. We don't expect an authority to speak about damages.
No, but
we need some facts, obviously, to prepare to work on our case. But I will comment later on with a practical example.
Okay. So, Catherine, maybe.
Okay. Thank you. In Germany, we have also room for a judicial review. So, settlements do not, or waiver of the right of appeal are not part of the settlement and cannot be. So our this is the jurisdiction of our federal constitutional court. So when it comes to an appeal by a company, the Bundeskartellamt withdraws its short decision and replaces this short decision by a long decision, which is then contested before the courts.
So no more.
Yes. So, as I already have mentioned, we have a lot of hybrid settlement cases, and still we see many advantages, even if not the case is settled as a whole. So, we have a decision which is good for plaintiffs, which is published, and the proceedings are longer the more companies are involved. So it leads to a shortening of the proceedings, and we have better evidence because the persons involved and the companies who settle are obliged to testify as witnesses before the court, and we also have the confessions made by them within their settlement declaration. So we still see a lot of advantages in hybrid settlements. And what we have is also decisions which are taken earlier, at an earlier stage, settlement decisions, and then the longer decisions afterwards. So what you described by the Court of First Instance, we think it's a very, very important also for plaintiffs and victims that we have a decision at an earlier stage. And our Federal Constitutional Court has judged that, not on a cartel case, but in other cases, that there is no interference with rights of the companies or the people that are mentioned in a decision divisions, as long as this is really just as limited to a minimum, a necessary minimum. But then, if this person is not accused, you don't have an interference with the presumption of innocence. So that's the view of our Federal Court of Justice on this point. So, yes, so maybe we can now start the
The last point is a very interesting one, because we saw in the ICAP decision that sometimes in hybrid cases it can be difficult not to mention the other company.
Really depends on the facts of the cases. But in ICAP, ICAP was a facilitator, so just the fact that we had to explain what is a facilitator already gave some hints as the legal assessment. So that's why we think that ICAP is a very specific case, and then we can still adopt staggered hybrid cases.
Yes, but you have to take into
Yeah, yes,
consideration,
of
of course,
Yeah,
this,
yes.
this case law. So,
So I think maybe picking up on that last point, the CMA, as I say, has only had experience of one hybrid settlement case to date. And our experience in that case, and we drew some inspiration, I think, from the experience of the European Commission, was to reserve the final decision for all the parties, including the settling parties, until we'd reached a decision in relation to the non-settling party, and in particular took quite a bit of care to ensure that we wouldn't be open to the charge that somehow our minds in relation to the non-settling party had been closed as a result of the settlement. There's no question that hybrid settlements are more difficult. They're more fraught with risk, I think, for the competition authority, and the procedural savings that come from settlement are to some extent eroded. And the key there, I guess, for us is around access to file. If you have to give full access to the file to one party and therefore go through the full exercise of identifying confidential information for the purposes of that disclosure, well, the fact that you don't have to do it for the other parties doesn't really help you enormously. But where we do see a benefit, as Katrine said, is that if you're going to be defending a decision against a number of parties, well, better that it should be against one party than against all of them. And we do build into our policy, as I said, a requirement on the settling parties that they assist with any appeals that may be brought by other parties. Now, how valuable that is to the CMA, to the authority, will depend very much on the extent to which those settling parties are in a position to assist. Because often I get the impression, dealing with parties, that they make a fairly binary decision quite early on in the case, and that's whether to cooperate or not to cooperate. And if the decision is to cooperate, everyone says they will cooperate, of course. Everyone will cooperate, but often all they mean by that is that they'll comply with their legal obligations. But in terms of going beyond that, usually, in a cartel case at least, if they've decided to cooperate and if leniency is available and if they feel that they have evidence that they can bring to the CMA, then they will apply for leniency. And that's how they can get the maximum kind of discount for their cooperation. Often the parties that don't apply for leniency but nevertheless settle down the line, that will either be because they've taken the decision, as it were, to keep their powder dry and wait. Well, let's see what the case is that the authority can build against us, and then we'll decide whether we want to settle or not, and that's a very respectable position to take. Or often it's because actually they don't really have anything to offer by way of a leniency application, because the individual or the individuals who are involved in the infringement either have left the company or they're not cooperating with the company, and on the basis of the documentary evidence that is available to the company, and of course they don't see the documentary evidence that we have from the other parties, it's not obvious to them that there's been an infringement, and they question whether they're really going to be able to add value if they come in for leniency. Now, those parties may well still get to the point where we're ready to issue a statement of objections, and they say, well, okay, we're interested in exploring settlement. We'll see the case that you're able to put against us, and then keep open the possibility of settlement. Now, those parties are not going to be able to assist us bring a case against a non-settling party, because the barrel's already dry. There's nothing there. So I think for the CMA, when thinking about do we go for hybrid settlement, do we not, one of the factors is going to be, well, to what extent do we think that this settling party, or this party, if it were to settle, would be able to assist us in bringing the case against this non-settling party. And that may well tip the balance in favor of going for hybrid settlement, notwithstanding the fact that the savings are otherwise reduced. I think, in common with Katrine's experience, I would say that the experience of defending cases in the UK before the Competition Appeal Tribunal is that that can be a very lengthy process. It's supposed to be a review of the CMA's decision, albeit a full merits review, so looking at the jurisdiction of the tribunal extends to revisiting the facts and not just the arguments or the reasoning that's put forward by the CMA. But in practice, it ends up being a complete rehearing. And the parties at the moment have the freedom to introduce new evidence if they want to. So in fact, the evidence that is before the tribunal may be quite different from the evidence that was before the CMA. And in a recent case, the CMA sought to exclude evidence which a party was introducing at the appeal stage in circumstances where they could have introduced it prior to that. And whilst the tribunal was sympathetic to the CMA's arguments, ultimately they allowed that evidence to be admitted. So the benefits of settlement are not just limited to the, for the CMA anyway, are not just limited to the access to file stage or the administrative stage. They do extend to the appeal stage as well. The parties, a settling party can appeal, and we cannot exclude their right of appeal. But in practice, once a party has got itself comfortable with the fact that it's admitting an infringement and that it's going to pay a fine, the likelihood, obviously, of them appealing is massively reduced, and we would still be able to rely on the fact that they had made admissions at the administrative stage, and they would lose the benefit of the fine reduction. So in practice, that we don't, to date anyway, we haven't had settling parties appeal. What we have had is settling parties trying to piggyback on the appeals of non-settling parties, and this was a very long-running case involving tobacco suppliers and retailers, where a number of parties settled. Other parties chose to appeal. They were successful on appeal, and at that point the non-settling parties who had not appealed and who of course by that time were out of time to appeal sought to reopen the case, and that went all the way to the UK Supreme Court, which eventually held that no, decisions are final as against the settling party. If they don't appeal within the time limit, then they have to accept the decision, notwithstanding that another party may have been successful on appeal, and that is now, as it were, baked into the leniency policy, in that one of the the settlement policy, in that one of the terms of settlement is that parties accept that the decisions against them are final.
Okay. Thank you very much. It's very interesting. Laurent, it's your turn.
Yes, in 2 minutes. Well, of course, the question is whether the glass is half full or half empty. It's clearly plaintiffs very much like settlement decisions because you have speed. You don't have to wait many years to have a decision. You have legal certainty. Most cases are not appealed. And you have a prompt publication. And again, if you compare the truck decision with the air cargo decision, air cargo we had to wait more than 5 years after the decision to have a publication. And that's a real nightmare for plaintiffs. Now, the glass half empty, if you look at the truck decision, it's the highest fine ever imposed by the European Commission in a cartel case. It's a hardcore cartel which lasted 14 years. And you have a 30-page decision. And in those 30 pages, maybe you have 3 pages about the functioning of the cartel. So as a victim, as a plaintiff, you cannot do much about that. And that's frustrating. Now there are solutions. And this morning I was discussing with Irene Luc. She was asking me, why don't you go to the Paris court? Well, with a decision like this one, you need to have some, I would say, some weapons. So what did we do? We went to the High Court in London, see Peter wrote, and we asked for a disclosure order. So we say we want to have access to the file, to Commission's files, from 2 truck manufacturers. No, what I didn't like that much is that the Commission wrote to Peter Roth saying, well, the plaintiffs are engaging into a fishing expedition. But how can we engage into a fishing expedition, if we have hardly no clues about the facts of the cartel? So we were asked to identify, categories of documents we needed, but obviously we were not in a position to do that. Then that the nice court about English church are very independent. So Peter Roth said, there's a disclosure order. DAF and Iveco must disclose to the plaintiffs 35,000 documents. That decision was appealed in July, and we won the appeal already in August, and we start receiving the documents. So there are solutions, and again, I'm not criticizing the Commission. It's a difficult balance to be found, and there are solutions for plaintiffs. I hope that tomorrow in France or in other jurisdictions, a judge will, adopt the same position. I'm not sure they are yet ready. It may change. But that's an important fact for plaintiffs. Also, what is frustrating for plaintiffs in Europe, if you look at worldwide cartels, look at Forex, look at several auto parts cases. You have decisions in the US, you have decisions in Asia, you have decisions in South America. You even had, damage settlements in the US on the Forex case. And we're still waiting for a Forex decision in Europe. Again, there are a lot of good reasons for that. But I would say that's something frustrating. So on balance, I would say I still very much prefer to have a settlement decision, because this allows the victims of the cartel to move ahead with a lot of hurdles, but there are solutions to overcome those hurdles.
Thank you. Do you want to add some remarks before I give the...
Can I just say on that last point, the CMA decisions, I think, are as full in settled cases as they are in non-settled cases, with the difference that obviously we don't have to address the arguments that are being advanced by a non-settling party. That is often a criticism that is made internally within the CMA. Well, couldn't we get these cases out more quickly? Why do we have to go through the process of giving all these details in circumstances where the parties have already made an admission? And of course, in a criminal case, the defendant simply pleads guilty. They don't you don't have any reasons. You just say guilty, and then of course the prosecutor has to explain the case to the judge in order that the judge can sentence. But actually, the reasons will be very, very limited. So there is clearly a wide range, it seems to me, of possibilities here, and there will be some winners and some losers in terms of how much we choose to put in. But at the moment, the CMA's practice is to give pretty fully reasoned decisions, and no doubt that is to the benefit of plaintiffs. Of course, if the incentive is then on plaintiffs, if you give short decisions and the incentive is on plaintiffs then to seek access to the file through the courts, well, one of the benefits of settlement is that you don't have to give full access to the file to the parties. If you then have to give it to the plaintiffs in follow-on damages actions, then not only have you done their work in proving the case, but you're also then undermining the benefits of settlement. So I think there's a difficult trade-off here that has to be arrived at, and I guess it's for the courts to try and work a way through that, and that's before we even think about the rights of leniency applicants and so on, which is probably for another round table.
Okay, thank you very much. We have now 10 minutes. Vous pouvez poser vos questions dans la langue que vous voulez. Je vous mets à l'aise.
Laurent Cohen-Tanugi, I'm a lawyer in Paris. I'm familiar with settlements in other areas of sort of economic crime, such as corruption, less familiar with antitrust settlements. So I have a couple of questions under the various jurisdictions. One is, to what extent do settlements include undertakings and monitoring of those undertakings? And my second question is, to what extent is there international cooperation between the various authorities as there exists in other areas? Thank you.
Thank you. I think it's mainly for Corinne.
Yes. So first of all, on the international cooperation for settlement, we have the same cooperation as in a normal case. What the first question? Yeah. Mm-hmm. Yeah. No, for us, the settlement procedure is only for cartel cases. So there is. It's an infringement decision, so there is no undertakings and no monitoring. It's a cease and desist decision.
You want to add something?
I mean, for the CMA, as I said, our experience of settlement has been mostly for the CMA, it's been exclusively for anti-competitive agreements, and it hasn't been necessary to impose directions. I guess if one were looking at a abuse of dominance case, then one may wish to impose directions, and one may agree those with the parties. Whether that would require any kind of monitoring, I guess that could be built into it or as part of commitments, but we don't have any direct experience of that to date.
So in Germany, it would be a different proceeding. It would be in an administrative proceeding where we look for future commitments. So it would be in a separated proceeding.
D'autres questions? Cela m'étonne un petit peu quand même. Alors moi j'en aurais... Oui.
En attendant que d'autres questions arrivent, j'avais peut-être une remarque sur un point qui a été soulevé par Monsieur Guéland sur que se passe-t-il s'il y a un plaignant assez énergique dans un cas d'abus, et comment est-ce que c'est compatible avec une transaction. Alors nous avons eu une expérience de transaction avec abus. Donc c'était la décision NJ que j'ai mentionnée tout à l'heure, et dans laquelle il y avait un plaignant. Donc ça nous a conduit à trancher des questions procédurales qui sont abordées maintenant dans le communiqué de procédure, puisque la loi française, lorsqu'elle définit la transaction, ne mentionne pas du tout le plaignant. Donc il n'est pas mentionné dans la procédure. Donc il y avait l'une des questions qui était, est-ce que dans l'audience orale devant le collège, le plaignant pouvait intervenir, et selon quelle modalité, puisque par ailleurs le procès verbal de transaction en France est couvert par le secret entre l'entreprise et les services d'instruction. Donc il y a eu une solution qui a été dégagée par l'autorité française au-delà des textes, qui était de dire que le plaignant pouvait intervenir à une première partie de la séance, tandis que la deuxième ne voyait que l'entreprise et le collège discuter de la sanction au sein de la fourchette. Donc ça, c'était un exemple un peu procédural de comment faire intervenir le plaignant dans la procédure. Nous avons estimé que dès lors que la procédure française était contradictoire et que le plaignant avait un certain rôle, il était légitime qu'il puisse au moins intervenir à un moment de la séance. Et ensuite, ce qui est intéressant, c'est qu'on a eu le cas de figure d'un recours du plaignant contre la décision de sanction rendue au bénéfice d'une transaction. Donc ça posait un problème intéressant. Alors la Cour d'appel a rendu une première décision intérimaire, puisque le plaignant demandait l'accès au procès-verbal de transaction. Donc la Cour d'appel a rendu une décision très importante sur ce point, puisqu'elle a affirmé que l'entreprise avait droit au caractère confidentiel de ce procès-verbal de transaction, et que le saisissant, le plaignant, n'avait pas accès à ce document. Et par ailleurs, elle a estimé que l'entreprise qui, en parallèle, avait présenté des observations en défense, celle-ci avait pu être retirée du dossier dès lors que la procédure allait en transaction. Alors le dernier point qui était peut-être le plus important, c'était le plaignant contestait la sanction en estimant qu'elle n'était pas assez élevée. Et donc, ça posait des questions intéressantes. Dans un cas de procédure de transaction, est-ce que l'entreprise pouvait être sous la menace qu'un plaignant vienne demander à la Cour d'appel d'avoir une sanction plus élevée? Nous avions indiqué à la Cour qu'il nous semblait que le plaignant n'avait pas à intervenir pour demander une sanction plus élevée, y compris en procédure de transaction. Mais ce point n'a pas pu être tranché parce que finalement, il y a eu un désistement de cette procédure. Donc, cette question reste ouverte. Mais c'est vrai qu'on voit bien que dans les cas d'abus, il peut y avoir peut-être plus fréquemment un plaignant que dans les cas d'entente ou de cartel, qui sont la majorité aussi des pratiques que nous avons eues dans l'autorité française.
Merci beaucoup, Madame la Présidente, pour ces précisions. Est-ce que cela a donné des idées pour d'autres questions? Eh bien, si dans ce cas, nous... Ah, pardon. Ouais.
I'm interested to know what are, according to the different authorities, the incentives to go for a settlement procedure. I understand that the most important incentive is the question of this procedural advantage, not to have, for example, a statement of objection. But is there also, I could imagine, for example, a case where the authority tries to make more imaginative case than the usual, and tries to get through settlement, actually decisions that creates a new trend of law or things like that. So trying through a settlement, not to have a challenge of a difficult legal reasoning that may be a little difficult in front of a court of appeal, for example.
That's not for Corinne, definitively. Maybe for one of you.
I mean, I think one of the, in deciding whether or not to proceed with settlement, one of the questions may well be, does the case raise important issues, novel issues of law that actually we might want to see tested before the courts? Having said that, of course, it's not within the gift of the authority to decide whether a case is tested before the courts. You can bring a novel case, and if the defendant decides not to defend it, well, there'll be a no appeal and there'll be no decision, no decision by the court. I think, though, it's those sorts of cases, perhaps, where the safeguards, the internal safeguards, become particularly important, in that I would expect a case team or a senior responsible officer who was going to our case and policy committee and saying that they wanted to settle this case or enter into settlement discussions, that this would be the sort of area that would be the subject of perhaps quite a bit of discussion. And similarly, at the end of the process, if the parties had agreed to settle and agreed to pay a penalty, then you'd get a higher level of internal scrutiny of the decision. I think ultimately, if the authority is confident and comfortable with the decision that it's making, well, it's really for the parties to decide whether they want to contest it or not.
You want to add something? No. So we are going to close now the panel. Je voudrais simplement faire une remarque en conclusion. Ce qui me frappe à l'issue de ce panorama de ce qui se passe chez nos voisins, c'est le fait que l'on a quand même le sentiment, en tous les cas c'est ma conviction profonde et je l'ai déjà exprimé, qu'il y aurait peut-être en tout cas il y a deux catégories de pratiques. Les cartels d'un côté, les cas hors cartel dont les abus de position dominante. Et l'une des questions qui se pose est celle de savoir si on doit avoir des procédures distinctes, qui est la voie dans laquelle s'est engagée de manière informelle la Commission, ou si au sein de la procédure unique que la loi nous impose en tout état de cause en France, on est amené à faire des aménagements. En tous les cas, c'est, semble-t-il, l'une des conclusions que l'on peut tirer de ce panorama de droit comparé. Et une deuxième petite remarque, mais qui n'a pas d'incidence, c'est la pauvreté de notre vocabulaire pour désigner sous un même nom, surtout en anglais, de settlement, des procédures qui sont en fait quand même si l'objectif est toujours le même, assez différentes dans leur déroulement. ce qui peut être cause de confusion ensuite. Voilà. Mais je ne doute pas que ces confusions seront levées dans le cadre du droit français par la deuxième table ronde, et je veux conclure quand même sur une note positive. Alors, il me reste à vous demander de remercier nos intervenants pour ce panel.